proceeding well, because I don't know at what point, if his explanation seems to be flowing. I know he has skipped even some areas which I wanted to bring to your attention. What he's doing is cherry picking, and that is not the understanding you committed when we started. You said they are here, they will present to us word by word, because I asked you that we should have had the opportunity to examine this bill on our own before they come.
Whichever method the director uses, he must be as clear as possible. Yeah. Whether you are fast or slow, you must combine time and clarity. So it is okay.
Yeah, so just to put you on notice that
it is okay. You let him try his best. Proceed.
Thank you, Chair. I proceed.
Draft as far as the provisions for restructuring the army, for improving the welfare of the officers and the militants, for decentralizing the pension authority, enhancing the compensation and fair payment in case of injuries, and to, I think, those ones, which I think goes a long way in addressing the concerns that existed within the country and complaints that come from the army. I am particularly interested in how the gaps in the payment, the salary structures will be addressed, which is one of the concerns raised here. Mr. Chairman, I have a number of concerns. The first is that one of the justifications for this bill is stated to be to align the Act, the UPDF Act, with the decision of the Supreme Court. My question is, what was the issue before the Supreme Court, and what was the decision? Which I will also attempt to answer. The question was, is it lawful? Is it legal? Is it constitutional to try a civilian in the military justice system or military court? That was the only question that went to the Supreme Court. And the answer was, it is unconstitutional, it is illegal. I want the movers to show me in this bill how you have complied with the decision. There was one decision that it is unconstitutional. Do not try civilians before the court martial. I want to find out where in this bill you have aligned that question, which was answered by majority unanimously, so that I can trace it. So far, I have failed to see it. The movers seem to have gone and created his own judgment, his own decision, his own orders, and then it is being used here. I would be very happy if that is pointed to me. And I could have even stopped at only that. But let me go to the others to help me. Stated,
Interjection from the minister.
it is stated, you will clarify.
Yes, some
you know, I wanted to interject.
No, to just help us know that we are reading the same judgment. Now that you are bringing that we could have set up our own judgment, can you refer us to the page of the judgment that you are referring to, so that we will look at it that we are referring to the same thing?
I will refresh your memory that this question of law was first before the Constitutional Court, and the Constitutional Court agreed with the petitioner at that time and said it is unconstitutional. The learned Attorney General appealed on the question of constitutionality of trying civilians before the court martial when it went to court, and you have quoted it here. It is in the Supreme Court Constitutional Appeal number 02 of 2021, Attorney General versus Michael K. And for me, I am just saying, you will answer.
We just needed just guidance, because if you helped us, it could help us to think, because if you point us to the part of the judgment that you're referring to, it will help us to understand what you, that's the concern.
When you presented here, citing different, did you tell us the paragraph and the pages? I'm following from you, because you say you are presenting, because we read, you presented here, there is no single paragraph of the decision that you have referred to. I can refer to your presentation, Learned Attorney General.
So you want us to provide you the
I will not do for you your job.
Okay.
Yes.
Thank you. So we are happy to.
Thanks. Yeah, and thank you, Chair. The second issue that I would like to raise is that the justification further says this bill, some provisions, some sections of it, are in compliance of the orders. You have also said recommendations. It has been used interchangeably, orders and recommendations. I want you to show to the full extent, not isolating one or two orders, how you have complied, how this bill complies entirely with those orders and recommendations, without isolating others. Maybe at some point you will now read to us the list of those orders one by one and how the order has been implemented. The other issue that is necessary for me to examine the certificate of financial implication. You state that there is lack of differentiation in the existing pay structure of the UPDF based on rank, and which has resulted in uneven pay for military personnel. Can the mover convince us and demonstrate the unevenness in the payment and the differentiation, and how much is required, providing the full details so that we can arrive at the figures stated or projected in the certificate of financial implication. I would also like to know, because bullet 2 of the PowerPoint presentation talks of addressing the welfare of veterans through the different mechanisms, which is very important, as the veterans have been complaining time and again. I would like to know specifically the figures attached to this. And Chair, the reason why I'm raising this is that we have not yet concluded the budgeting process. And I know next year there will be budgeting process. We do not want to reach a point where we have provided for in the law and then the same government executive appears and tells us there is no money to enhance. Because from this, there is enhancement spread all over in pensions and gratuity and etc. So we would like to know the figures attached there. I am not yet done. Yes, thank you. Something small, of the forces, the two exist, and they are called the Land Force and the Air Force. We want to add two more, the Reserve Force and the Special Force. Of the four, only one is given the word command. The rest, Land Force, Air Force, Reserve Force. But this one is said Special Force Command. I am not subject to military law. The use of the word command in law, is it creating a superior force over and above the rest? Because if I am the one Special Force Command, and I just want to understand whether that is the spirit, so that when I'm making a law, I can explain that there is now a superior called Special Force Command, and yet the others are command. Or it is best to call it a special force and then remove the command. That is my concern, the use of the word command, not on the speciality it is. It can be special in other ways, and that can work. There is offense. I don't want to go to offense. In your understanding, what is a service in the defense forces? What is a service? And I'm heading now to the issue of trial of the civilians. I have looked through other sections. You have stated that if I get injured, there are now calculations on how I should be paid 100%. You also seek to conscript a civilian for purpose of trial, if it passes, to be a militant, meaning with a force number and etc. So let's give the example of live cases that are happening. And I'm not saying it is true or it is not. The allegation in some of these is that there are a group of people who were involved in aggravated robbery, and they are being tried in massacre with the one Eddie Mutwe and the rest. I presume if this law was enforced, you would give him a militant or a force number, and then you try him. And I want to believe that the military court-martial can convict or also acquit, because it is a court, it can do either. After acquitting him, with all the torture injuries, is he qualified to be compensated? Because he's now a militant. That you now compensate him in that process. That's the question of law that should be answered. Minister, you take time, don't be discomforted by this. It's just a practical question. It can happen to all of us. In fact, can happen to you as well. The question is, a civilian is accused, and the allegation that you have committed murder, the offenses you have listed under the Act. For purpose of this trial, you are proposing he or she will be assigned a rank or considered a militant if it does not have a higher something like that. Because for you to be tried for a service offense, you must be in the service. That's my interpretation. You must be in the service. So if the end result of that trial process is that I am acquitted, and I am saying this because I believe that the court can convict, can also acquit. I don't know, maybe the judge advocate could tell us how many trials has led to convictions and how many has led to acquittal. But now, because of that, I am now part and parcel of your structure. I now choose to continue being a soldier after acquittal. Will you even continue with me? That's the first question. Then the injuries that occurs to me in the process of being considered a militant, and there is a provision for this act for compensation. Am I also now entitled to compensation because I have militant? How do I retire my rank as a corporal that you assigned to me, or how do I retire now from the military service? It's a question that I think you could help us answer. When we go to exceptional circumstance, who determines the exceptional circumstance? Because the offenses here are triable. If the act passes through, there is a choice to try it in the civilian jurisdiction, the courts of judicature, the ones we know, High Court Criminal Division, but you also want to try, the choice to try in the court-martial. So if I contest that there is no exceptional circumstance, who? Is it the civilian courts first to look at it and say, we don't have, this is an exceptional circumstance, I agree, so you go? Or if I prove to the military court that I am not under the purview of the exceptional circumstance, do you then send me to the civilian court? What happens there if there is contestation over the definition of exceptional circumstance? I want to now end, and Chair, you will allow, because these are the things that if we had harmonized. Now, the question on independence and impartiality was cited by the Supreme Court. In arriving at that decision, which is, it is unconstitutional to try a civilian. They had examined this. And the question of independence and impartiality was not addressed in terms of taking judicial oath, in terms of qualification. It was built on the cornerstone of our democracy, the triangle, that an accuser cannot be the one bringing, because all criminal cases are brought in the name of the state. And the state is controlled by the executive. So if it is the executive making this complaint, and then it's the same executive which has enforcement control over the army, is the one going to accuse and prosecute and judge. That is the purview under which the Supreme Court and actually Court of Appeal said it is unconstitutional. So the independence and the impartiality is not in taking judicial oath. It is not in asking Judicial Service Commission to consult them, not even with a recommendation. Your use of the word here is to consult, which is different from the practice of what is happening with our judges. It is recommendation, but here you are saying consultation. So how can the one in control of, I can even use the word, if I don't know, you will help me, when Dr. Besigye was acquitted, I think by one of the judges, he used some words. How can somebody in charge of concocting cases, fabricating charges, manufacturing evidence, and then be the one then to judge? Because the total chain is controlled by them. From the accusation to the assembling of the arsenal for persecution and prosecution, it is the same person. How can I then be sure that that person is going to decide in my favor? That is the question, on the basis of which the Supreme Court said no. Because the control of the three arms of government is well known to you, learned Attorney General. I still have many chairs, so I don't know. I see you're impatient.
First, take a break. The Honorable Jonathan Odur is there.
193 of his judgment, and taking oaths. He talked about taking oaths that you are talking about. Taking oaths is one of the issues of independence. Impartiality, both subjective and objective, is legal qualifications is part of the independence. How can you be independent rendering judgment when you have no knowledge of the law? Composition was part of this, tenure, manner of appointment. So all those are part of the independence. So if what we are trying to do here, honorable colleagues, is we are trying to clothe the General Court Martial with all these different tenets to try and give it an independence. Now we'll ask for your guidance if you think there's anything that we have indeed left out, and we shall.
Because you seem not to have understood me. I was addressing the two-color relationship between the three arms of government.
Yes.
And I think that is the gist of what the Supreme Court addressed, that the executive has the control. These charges are brought in the name of the state, controlled, and you are the one in charge of deciding on this and fabricating or manufacturing.
Just like.
So, yes. So yeah, that's where I want you to know.
I get what you're saying, but I think.
And maybe now I can add this so that the army can help us understand. You talk about the oath. There are also oaths that are taken in the army, the oath to obey maybe your army commander or something like that. So if we give the example now of what is happening, and a brigadier general is now presiding over, and an order comes from a superior officer.
I think the most important.
That's what we are talking about.
I think the most important thing is that this oath that we are talking about is in the Constitution. The other one is in the Act.
And I can say there is evidence that in one of the proceedings of the court-martial in this country, before a decision was taken, it was taken to be discussed in the High Command, whether it should proceed. History has it. So that's the kind of interference we are talking about. That if a court that should make a decision then says now we go to the High Command whether now we should do.
And honorable.
So that's what I want.
That's what we are trying to cure here. So a stage where we believe that this jurisdiction is dropped in a particular way. For example, for appeals to an election petition, this Parliament said you will not appeal to the Supreme Court. So what this Parliament vests you with is what you use. The industrial court was vested with mandate and sent to the Court of Appeal. It was by this parliament. So the constitution did not tell this parliament where to vest the jurisdiction. So you can vest the jurisdiction. The
No,
question
but you
is,
see at that point, as you realize, the court, the industrial court was not being presided over by high court judge.
and now we are, you see, the industrial.
That's why we said no, we cannot have a high court judge in the industrial court taking a decision that is being looked at by a judge of the similar rank. Therefore, it should go up.
I think that is a conversation you'll have, but you must remember that the industrial court also has 2 civilians who are not necessarily legally trained.
AG,
So, but that's a conversation that what I need to state as a matter of law, the decision on the jurisdiction to be granted to any tribunal or court vests with the parliament. So we are asking you, parliament, to grant the Court of Appeal jurisdiction over the decisions of the General Court Martial.
AG, this is just for your take home. I beg to disagree with the use of the example of the industrial court. We are talking about a criminal offense here. It's homework for you, but I want you to address that.
I think it's homework for the parliament, because me, I am not the one who vests jurisdiction.
Yeah.
Me, I've asked you, and I've told you what we think, and the reasons why we think so. Now,
Mr. Chair,
Okay.
we are not trying to pull ropes here. Like we are listening to him, and we do the correct thing
Yes.
for the...
Are you persuading the Attorney General such that the appeals go to High Court?
Yes.
Is that what you are saying?
Yes, that's what
Okay.
we've been saying. But he can think about
What
it
if-
if he thinks it makes sense.
But it's also important.
Or
to
you are
note-
leaving here to us just
we shall
to
think
decide.
about it and also share with you whatever other material we can find on
Yeah.
this.
Like,
But it's also
Okay.
important to take note of what he has said. Jurisdiction is really our mandate. Yeah. Could we-
responsibly.
Yeah, sure.
Okay. Civil.